Welcome to PGurus channel. I'm your host, Sri Iyer. Cauvery. Finally, the Supreme Court has spoken. They have given their judgment. Tamil Nadu is going to get a little bit less than what it used to get before. And this judgment is going to be active for 15 years. So Tamil Nadu has a challenge on their hands. They have to make up the shortfall somewhere. They'll have to find new ways to create water, potable water, irrigation water, and essentially, water that is usable. To talk about this and other things, I have a very special guest on our channel today. He is a famous TV anchor. He has anchored many sports programs and other programs. He has been a television commentator. He is actually a doctor in real life. He's also very versed with computer applications. He works for an IT multinational company. And you've seen him probably in Times Now or in Republic TV or many other Indian English channels, in addition to Tamil channels. Welcome to PGurus, Sumanth Raman.
Thank you.
So, as I was describing, the Supreme Court judgment has just come out, and it looks like Tamil Nadu is going to get about, give or take, 15 million TMCs left. And I could be wrong about the number, but it's the number is the units are 15 less now from 174 or something like that. I'm sorry about the numbers, but essentially Tamil Nadu is going to get a little bit less than what it used to get, and it does need to solve this problem on a long-term basis, because when there is a flood, they have to figure out a way to store that water, not just let it drain out to the sea. And with all these challenges, how do you see Tamil Nadu tackling this Cauvery challenge?
I think yesterday's judgment has some good elements for Tamil Nadu, as well as the negative side, which is the reduction of this 14.75 TMC feet of water. Now, originally, Tamil Nadu wanted 264 TMC feet. That got reduced in the tribunal's verdict to 192. And now 192 has now been further reduced to 177 odd TMC feet of water. Now, the reduction, let's look at the judgment itself. The key part of the judgment, which I found difficult to comprehend, was the reason given for the reduction. And out of this 14 odd TMC feet of water that has been reduced, 10 TMC is being reduced because Tamil Nadu has groundwater. Now, Tamil Nadu has made detailed submissions of the groundwater levels. Karnataka has not. So, in the judgment, they say that Tamil Nadu has adequate groundwater, and therefore, because of the groundwater, we are of the opinion that 10 TMC feet can be reduced from their quota. Now, logically, you would expect that the same groundwater estimation would be done in Karnataka. And proportionately, we would know what is the quantum of groundwater in Karnataka. Unfortunately, the same in the judgment, we find the sentence saying that Karnataka has not provided accurate estimates of the groundwater levels there. Now, on that basis, Karnataka has not provided groundwater estimates. Tamil Nadu has done their homework and has done their study and provided groundwater estimates, and therefore they will be penalized 10 TMC feet of water. Seems a little odd, to say the least. The other point is about this 4.35 TMC feet of water for Bengaluru city. Now, while one understands and appreciates that a mega city like Bengaluru needs a source of water supply, whether Tamil Nadu should be sort of deprived of 4.35 TMC feet because the Karnataka government has not managed to create infrastructure for providing water for Bengaluru is another point. Now, having said that, these are the negatives in the judgment as far as Tamil Nadu is concerned. The positives are very many. One, the earlier agreements, the 1892 and the 1924 agreements, which Karnataka contested, were not even signed in independent India, and therefore they are null and void. Now they have been upheld. So that effectively means that whatever the water sharing agreements that were signed earlier between the Madras state and the Mysore state, that still holds good. The second very, very important point, and this is where we have to wait and see what happens, is the court clearly says that the center must evolve a mechanism within the next 6 weeks to give effect to this order. Now, the center, we know, has been dilly-dallying on the Cauvery Water Management Board, which was ordered to be appointed quite some time back. They waited and argued in the Supreme Court, and then finally went back and told the court that the court does not have the jurisdiction to order it, and it should be done through an act of through Parliament, and never followed up in Parliament either. So now the court says, under no circumstances will an extension of this 6-week timeline be given. So that's a huge positive. We must understand that Tamil Nadu has been receiving consistently in the range of 100-110 TMC feet of water every year from Karnataka on an average in the last few years. So this is nowhere near the 177 even that has been stipulated by the Supreme Court. Forget the 192 which was the earlier order. We were getting last year in January this year, the Chief Minister wrote a letter to the Karnataka Chief Minister Siddaramaiah, where he said we have received in 17-18 only 111 TMC feet of water. So Tamil Nadu, yes, I would say Tamil Nadu is disappointed with the reduction of 14.75 TMC feet, but the key is this order actually going to be implemented? It definitely needs to be. This is the order of the highest court of the land. And again, if political parties, especially Congress and BJP, play politics over it because of the elections in Karnataka, that would be a travesty of democracy.
Well, what happens if the rainfall fails in a particular season? Did the court judge on that and say that there's a proportion that needs to be worked out?
Yeah. What the court has actually said is the court has calculated the catchment in the Cauvery basin, and they have apportioned the water accordingly. And they have gone by the tribunal's earlier order, which says that there shall be, in years of distress where the water flow is not as to the expected levels, there will be a proportionate reduction in the shares of each state. So that was the order of the tribunal. So there was no express distress sharing formula in terms of multiplication, division, numbers, percentages given. But it was very clearly mentioned, even in the tribunal order, that in years where the Cauvery water was not adequate, the distress shall be shared in the same proportion at which the tribunal order itself was, now the Supreme Court order. So one assumes that should there be a deficit, the distress will be shared in the same proportion.
So let's look at the other side. When there are floods, for example, so the gates get opened in all the dams through that are dammed on Cauvery, and excess water just flows to the ocean. Instead, now the way most economies plan is what they have are what I would call as temporary lakes, which are essentially gated, meaning these are lakes that can take the excess water, and as the excess water comes in, these lakes can be filled up and can be used as extra storage spaces. Now what they have is it's like a dike and a sluice and a gate, so that the water doesn't just keep flowing afterwards. You know what I'm saying, right? It's a controlled inlet outlet. And what it also makes it happen is that when there is a lake with water, the ground table, water table also stays a little bit higher because of that, because it finds its way around, and therefore instead of 90% of the extra water flowing into the sea, you'll have all these satellites that can essentially take that water. Maybe you can conserve like 30-40%. I'll give you an example. We had these excess rains in Chennai 2 years ago, I think, and because of the fact that the dam was a mud dam, they were Chembrambakam area, I think. They were afraid that it might break, and therefore they just let the water flow to the sea. Now, evidently, what I read afterwards was that there was a contract given to dredge it. And supposedly, out of 100 lorries that were supposed to do dredging, only 50 actually did the job. The other 50 was eaten due to corruption. If they had done that, they could have, Chennai could have enjoyed at least another 6 months more of fresh water.
Okay. I really can't agree with you entirely on this, because I think after the 2015 flood assessment, what was the reason for the devastation. We found that the Chembrambakam water release was only partly responsible for the devastation, and it wasn't even the single largest factor. One of the major problems is encroachment on water bodies across the state, and not just small lakes and ponds. Major rivers, the Adayar in Chennai, we went around to some of the areas where on paper, the Adayar river is supposed to be 190, 200 feet wide. In those places, the Adayar river was 30 to 40 feet. That means nearly 140, 150 feet encroached. So corruption is a problem, encroachment is a problem, and these are issues which have to be sorted out. But these have got nothing to do with Tamil Nadu receiving its legitimate share of water from the Cauvery. Now we have to receive our share. The fact that we are not doing our internally cannot take away from the fact that we are entitled to a certain share of water which we must receive.
True, I agree. So in terms of planning all these satellite lakes, I don't know if the government is thinking along those lines. What are the government's thoughts? He can play victim, but this is now a Supreme Court judgment. It has been delivered by the Chief Justice. I don't know what other judicial options that Tamil Nadu government has. Rather, I would say, is it looking at what else can it do?
Look, the government has already started a fairly large desilting program last year. And some progress has been made. I mean, is it spectacular progress? I don't know. But honestly, some progress has been made in the desilting process. Now, other than this, there's also an ambitious scheme which has been drawn for putting up thousands of check dams across the state. Now, all of this is our internal work that Tamil Nadu will do, and Tamil Nadu has to do it. We have not done it for so many years. That is the fault of the various governments that have been in office. That's a different issue. Having said that, now the focus of this government has to be on ensuring that this 177 odd TMC feet of water is released by Karnataka. The court also specifically said in the judgment that the monthly scheduled releases will be maintained. Now, I think that is very critical. There is no logic in saying that when the water is needed, so typically you see the water is typically needed in that particular period from July, August, September, October. That is when the maximum flows are expected. Correct. And if Karnataka says, I will not give you at that time, instead I will give you when, supposing there is a flood at some other time, it doesn't serve the purpose of Tamil Nadu. So not only is the total quantum of water important, but the monthly distribution of it in the format already assigned by the tribunal and now by the Supreme Court must be maintained. What the government is going to do to enforce it? We can only go the legal route. Now, the center does not do anything in the next 6 weeks. And I honestly think that they will find some way to wriggle out of this because elections are coming in Karnataka. Neither the BJP nor the Congress will want to rock the Cauvery boat at that time. So they will find some way of delaying it. Either Karnataka government will file a review petition or center will file a review petition saying 6A, which has been struck down by the Supreme Court, should be retained. Something will be done to delay this whole thing. But the point is, we need the central government to be fair. Tamil Nadu is not asking the central government or anybody for a favor. We are only saying, here is an order of the highest court of the land, kindly implement it. And I think that it's the duty of any government at the center not to take sides, not to look at the political advantages of what could accrue, because you could potentially come to power in Karnataka and you are not going to come to power in Tamil Nadu, cannot be a reason for depriving a state of its fair share of water which has been ordered by the highest court of the land.
Let me play the devil's advocate for just one moment, if you will bear with me. See, if you look at the numbers, just the numbers, Karnataka has come out ahead. So don't you think the Cauvery water is going to be off the table for the elections?
No, see, yesterday, because there were celebrations in Karnataka, there were people distributing sweets and bursting crackers and so on, one assumed that they thought it as a victory for them. Now, by end of the day, by last night, the tune had already started to change. I was on a debate on Times Now, where one of the representatives of the Karnataka Pradesh Congress Committee came and said, no, that some people might have distributed sweets. Now we have to look at the judgment. We may choose to file a review petition. See, the bottom line is, the water they have to sort of accept in principle the very, very important order of the Supreme Court that the river does not belong to the upper riparian state, in this case Karnataka. It is the property of the nation. And I think that that is a very significant part of yesterday's judgment, that it is not that Karnataka's river and therefore they will decide how much water to give. That is not the case. This river belongs to all. This river belongs to the country, and therefore it cannot be dependent on what Karnataka wants to do or not do. This verdict has taken decades for a final verdict resolution to come. And now, if you are again going to play politics or going to say I'm going to flout the orders of the Supreme Court, then what is the concept of democracy in India and rule of law and justice?
I think you make an excellent point. Water is a national resource. It's not something that a particular state owns just because it happens to be near the catchment area. Thank you very much, Sumanth ji. We will come back.
I have only one final point.
Sure.
You see, the eventual solution would be to take control of the dams for all interstate rivers and hand them over to a central agency. Now, that is the eventual solution. Unfortunately, water being in the concurrent list cannot be moved to the central list without a constitutional amendment. So the problem is, it's not so simple tomorrow to say, let the center take control of all dams on all interstate rivers across India, and they will decide based on the judicial verdict or on the verdict of tribunals how much water goes to whom. Now, that is the eventual solution, but that can't be done without a constitutional amendment, and a constitutional amendment is going to be difficult given the current political situation. So that is the fundamental problem. One can only hope that good sense prevails and the center sets up this mechanism within the next 6 weeks and ensures implementation of the order of the Supreme Court.
I couldn't agree with you more. This is an excellent suggestion. Before I sign off, I just wanted to relate to you one story. About 30 plus years ago, the same problem, I mean, this problem has been there for a long time. 30 plus years ago, M.G. Ramachandran was the Chief Minister of Tamil Nadu, and Ramakrishna Hegde was the Chief Minister of Karnataka. So to discuss this water allocation, that time also Karnataka was not releasing water. MGR had flown down to Bangalore, and he went to Ramakrishna Hegde's house. And Mr. Hegde was not at home. As soon as he went home, Hegde's mother gave MGR a glass of water and said, please drink water. I'll let my son know that you have come. So MGR said, really, ma'am, I don't want water. My people are in dire need of water. I hope you understand my problem. I can't drink water here. And he stepped away. So the evening, when Ramakrishna Hegde comes home, he comes to hear from his mother the conversation. And that night, he released water because he understood that unless the water comes at that time, the crop is going to be damaged. Now, you had at least some amount of leadership at that time who understood that, you have to rise above these things. So I'm really hoping that the upcoming elections in Karnataka doesn't sour the pitch, and they accept that the highest court of the land has decreed this way and that we should move on beyond this.
31st of March, when this 6-week deadline ends, is actually going to be when campaigning is going to be at its peak in Karnataka. So we'll have to wait and see.
Thank you very much, Sumanth.